violation appeals of petitioners Dakota DeMoss and George Harper, 21-249-RFB, with the appeals of their termination, 21-253-T and 21-252-T. Do you have any motions?
I'll move to reject the consolidation. I think it's just, there's too many moving parts and too many reasons this commission, not to create more work for us, but there's too many reasons that we need to hear them all separate.
Is that a motion to deny it without prejudice to their ability to bring it at a later date?
Yes.
Any discussion?
Second.
It was seconded already. All right. Part of the issue involved, obviously, is what we have to take up next, and that's the issue of the stay. There might be different time periods involved with the appropriate stays of the different appeals, and so I speak in favor of the motion to deny the request for consolidation. Any other comments? All in favor of the motion which would deny the consolidation, say aye.
Aye.
Any opposed? The ayes have it. Item number 6 is consideration of motion to stay the appeals of Dakota DeMoss, number 21-253-T, and George Harper, docket number 21-252-T. Do we have a motion?
I'll move to deny the stay.
Well, the motion is to deny. Do we have a second on the motion to deny? Okay. There are ongoing criminal investigations in this matter. I would not support the motion to deny the stay. I think in light of our previous actions and other similar cases where there were criminal matters pending, I'm opposed to the motion, but I mean, that's just my personal opinion.
Well, explain to me real quick the legal implications, because you know I'm not a lawyer. So I may have made a motion in conflict with what I just knew.
I happen to agree with the motion you made, because, and the reason for that is I think we should be treated, especially if these are allegations involving excessive force, that we should be able to move forward and not, there's a public interest in moving forward with, in a timely fashion with certain matters, especially those dealing with excessive force. I would agree with the idea that we should move forward and with the appeals.
Got a motion, a second, and some discussion. Any other discussion?
Mr. Chairman, restate the motion.
The motion was to deny the request for a stay, as I understand it. Any other discussion? Okay, all in favor of the motion?
I'm creating a policy, which is
No, it's well, Commissioner Knapp believes that it's appropriate motion, so I think we need to move forward.
Yep.
See where it falls.
There you go.
All in favor of the motion which would deny the request for a stay, say aye.
Aye.
All opposed? No. Ayes have it. Okay, we'll move to item number 2, oral argument on the motion to reconsider the motion to stay the appeals of Dakota DeMoss, docket number 21253-T, and George Harper, docket number 21252-T. Good morning. Would you identify yourself for the record, please?
Good morning, Commission. My name is Adam Karamanis, here on behalf of George Harper and Dakota DeMoss. And I'm here this morning to ask y'all to reconsider the motion to stay the appeals of my clients. About 2 weeks ago, the last commission meeting, that motion to stay their appeals was denied. I believe that a motion to stay is proper in this case because my clients were arrested for the same event that state police has provided as the basis for their termination from state police. And moreover, my clients have also received target letters from the DOJ indicating that they're the subjects of federal investigations as well. Now, the status of their charges in the 5th JDC where they were arrested, they have not yet been arraigned, but that's the current disposition of the case. And we believe that the stay would be proper here because, as I mentioned, because the matter is the same here for the basis of both their appeal and their arrest, allowing the appeal to proceed for this commission, my clients would be placed in an untenable position where they're essentially having to choose between appealing to hopefully get their job back or invoking their Fifth Amendment right to avoid potentially incriminating themselves in criminal matters that are currently pending. And so they would have to take advantage of their Fifth Amendment right, and they wouldn't be able to testify, they wouldn't be able to ask questions here, they wouldn't be able to tell their side of the story for their appeals in their own words, which, as this commission knows, that's a crucial part of any appeal. And I also want to point out that most recently, this commission granted a similar stay in a very similar matter in the case of Lieutenant Perkins. I don't want to get into details of all that, but he requested a stay pending the resolution of his criminal matter, and I believe the stay lasted for well over a year. And upon the completion or the resolution of his criminal matter, the stay was ended and he proceeded with his appeal, and that's what we're seeking in this case.
Does the agency have any comment?
We have no position on the stay.
Any commission? Commissioner Knapp.
I have just a few questions. First, I am assuming that the investigation and the termination from the department, maybe the department they want to come up, the same rights lay with that when they were making the decision dealing with the termination. Is that right? That the termination was ordered by was ordered in this case. Is that correct?
So an administrative investigation was done, and during the administrative investigation, the agency can compel an officer to come in and make a statement. And if they get the Garrity warnings, which say that nothing they say in that statement can be used against them criminally. So we can compel the statement. And based upon the entire administrative investigation and the criminal investigation, the decision was made to terminate the employees. I don't believe either employee, Mr. Karamanis may be able to elaborate on this, I don't believe either employee waived their Fifth Amendment rights in the criminal case and made a statement. That's the only case the department has ever taken a position on a stay. In one case, we opposed a stay before the commission because the employee did waive their Fifth Amendment right in the criminal case and made statements in the criminal case admitting to the conduct. And we felt there wouldn't be any waiver of any Fifth Amendment right in a proceeding here because they had already done that.
I would like to get a little more information on what the effect of a stay would have insofar as things before the, is it with pay at this time?
No, sir. They've been terminated effective.
Whatever dates they are in a letter.
It was June of this year. I don't remember the exact date.
Okay.
June 4th.
Now, so if they're receiving pay, it's because of their, they've got vacation.
They're not receiving pay. They are terminated. They are no longer state troopers at this point. They're appealed to this commission. Once you hear it, if you choose to overturn that discipline and put them back on the job, they would possibly be entitled to back pay. So they are no longer state troopers at this point.
But can't they use their accrued leave that they
No, sir.
can't do
They
that either?
They're paid out.
They get paid 300 hours of annual leave, and the rest of the leave is wiped off of the books unless they get their jobs back, then it will be restored.
I understand. Thank you.
I might add, Commissioner Knapp, that if circumstances developed where there was a hearing and the terminations were overturned, the commission then still has the right to not allow back pay from the beginning of the request for the stay until the time of the hearing. So there's not an entitlement to back pay should the termination be reversed.
As we did in the Harper.
Correct.
Commissioner Crawford.
Yeah, just a couple of things. So I know what's before the body is to extend a stay, but this employee's been terminated, so wouldn't we have to bring the employee back first, then stay the, how do we stay?
You're just staying
The
his
appeal.
appeal
Okay.
before you're not gonna
I
docket
got
the
you.
appeal.
Okay, so the second question is hypothetically, if they hadn't been terminated and the investigation went on, the colonel made the decision that, hey, we're gonna just put them on leave until the criminal investigation is completed, what would their circumstances be as far as, would they be entitled to leave with pay, leave without pay, or is that the discretion thing? I think I remember that he's got some discretion after so many days, I think, so.
I guess I'm not understanding the question.
So
The
if
right
he-
of
if
appeal
he had
is.
not been, if he had not been terminated,
Yes, sir.
and the colonel made the decision that we're not gonna terminate you, but we're gonna put you on leave until your criminal investigation is complete, would he have been put on leave with pay or without pay, or does the colonel have the discretion?
I
There would
guess,
have had to been some discipline.
yeah, we have to complete the administrative investigation within 60 days or get an extension of time. At the
So-
conclusion of that, the decision to discipline has to be made, so.
So the time that the investigation is going internal and the employee is on leave, is he being paid or is he not being paid?
Well, there is paid administrative leave,
Okay,
if the colonel
that's my
chooses to use that, yes, sir.
Okay, that was my question.
And they received that benefit in this
Right.
case, but that's over.
That's kind of what I was.
Yeah, I can't comment on that. We do have the opportunity, I think the current rule is 400 hours of paid leave pending an investigation.
Right.
If it goes beyond that for some reason, we have other tools, forced annual leave. I can't tell you in this case, specifically if
Sure.
it went over that time or what, but.
Any other questions?
A couple of, I guess, statements or questions, Mr. Chairman. In regards to using the criminal arrest as basis of terminated employee, that's where I have a problem with combining the two. For example, I'm reading here, if I can, your actions are unreasonable force. Can I read it? Okay. Okay, result in an arrest for simple battery and malfeasance in office. Okay, so if you take that sentence out, the arrest or administrative, those are two criminal aspects of the termination. By combining the two is kind of what I have a problem with. If the department stays away from, in its termination letters, the criminal aspect, I wouldn't have a problem with the aspect of staying it, but now, or maybe not staying it, but I think we kind of have to, in my opinion, limited knowledge because the two are combined. And I think that kind of causes some issues with the amendment, right, for the employee. As I understand it, again, I'm not an attorney, but I think the department has the ability to terminate someone just for administrative purposes. If they got arrested and had no administrative issues, then I think we have to wait to the outcome of that arrest. But this situation, these two are combined. The administrative aspect, and you also were arrested for simple battery and malfeasance.
So, if I can comment, they weren't terminated because of the arrest, but the facts that form the basis for the arrest and the administrative violations are the same. That statement is just a factual statement. In this appeal before the commission, we don't have to prove criminal conduct. We don't have to prove a conviction based upon those facts. The conduct is the conduct,
So why mention it? Because there's going to be an outcome.
give this commission the information that there are criminal charges pending against these employees.
Okay, well that's part of the problem that I have is combining the two. That's it.
Commissioner Knapp.
With regard to the criminal charges, that the investigation was referred what is the status of, has a bill of information been issued or a grand jury panel that and returned a,
No, Commissioner. They've only been arrested. They're awaiting arraignment. That's all we know at this time. And as I said, they've also received DOJ target letters for federal criminal investigations as well.
And how long has that been pending now? When were they referred over to the district attorney's office?
They were arrested back in February.
February.
Yes.
And so it's been since February that there are charges made.
That's correct. I would like to point out, we don't have any control over that, Commissioner. That's obviously the DA's office. Unfortunately, she doesn't answer the first-year associate attorneys, but I'll let you know if she does.
I'm very familiar with that.
Any other questions? Any other discussion? We don't have a motion, right? No one's made a motion yet.
Right.
Well, he's made a motion,
He's made a
but no
motion.
one on the commission has made a motion. Well, there is consideration, so we either need the motion to accept or reject the request for reconsideration.
Mr. Chairman, I make a motion that we reject the motion to reconsider the motion to stay the appeal to go to DeMoss and George Harper.
I'll second. Any discussion on the motions itself? So the motion is to reject the request for reconsideration, is that correct?
Correct.
All right, so a yea would be to keep the status quo and to not grant the stay. All in favor, say aye.
Aye.
Any opposed?
I'm opposed, yes.
So the ayes have it,